So Joe Heath is well known in these parts, all right? He's so well known that he has a brand of coffee named after him. If you haven't noticed, on the coffee urn, you're drinking a Joe Heath blend from Freedom of Espresso. And there's a whole story behind that. But Joe's well known. He's the general counsel of the Onondaga Nation. But he's been very involved in efforts to push against hydrofracking coming into this region. And he's done, well, he could go on. But it's very good. I'm very glad he was able to come out today. Thanks, Joe.
Thank you for those kind words, Phil, and thank all of you for coming to this important conference. I want to start out by apologizing in advance. I haven't had as much time to prepare for today as I normally would, and I think that'll be clear in a few minutes when I explain what we've been doing the last few weeks here. Generally, I was asked to talk about the Onondaga land rights. It is shocking to look out at that lake from here. Look across that lake at what they've done to the other side. Look at those smokestacks. Because that's what really is going on here throughout Haudenosaunee country. So I was asked to talk about the land rights and the recent filing in the Organization of American States. We'll get to that in a minute. And then also to talk about how the doctrine of discovery has permeated U.S. Indian law, how it's been used since 1810, actually, and used continually ever since, and try to tie some of that together just from the legal perspective. But first I want to share with you just some recent experiences that our office has been through, because I think what is going on within Haudenosaunee territories as we speak helps us understand the importance of these foundational problems of U.S. Indian law. And we have some very severe interferences into Indian country here on Haudenosaunee territories in the last 6 weeks. So we filed in the OAS on April 15th. That was a bit of work, I have to say. We had 6 months from the time the Supreme Court denied cert, and it was quite a bit of work to get that together. And I thought I might get an hour off the next day. Well, it didn't work out that way, because by the next afternoon, we started to get information that a surrogate court judge in Genesee County had issued an order that sent sheriffs and troopers onto the Tonawanda territory. We have been fighting that case since last May. I entered it as litigation counsel, and we finally convinced the judge that he couldn't decide. So this is an estate case where one of the former smoke shop owners had never paid any attention to Tonawanda law and made millions of dollars ignoring New York law by not paying taxes. Then builds this huge house, and then writes a will, and his daughter runs into state court and says, now I need state law to get all that loot back. So that's the context of it. We finally convinced the judge after about 8 months that he could not make a ruling about who owned or occupied or used land on the Tonawanda territory. He was going to rule that he could decide. He did order, actually, that a deed be filed, 2 deeds be filed. So that's where we started a year ago May. We backed him off on that. Then it came down to the personal property, both within the 2 businesses involved, a cigarette store, gas station, and a restaurant, and a house. And so now he has ordered the troopers and sheriffs back in there to reclaim that personal property. We backed off from, they did go on one day without any notice. I've been trying to deal with the governor's office about that. And we got that order stayed by the appellate division, but it was just reissued yesterday. So that saga continues. And then, as I was sitting here about 3 weeks ago, and there was a presentation that Rick Hill was giving, I started getting texts on my phone about problems at Cayuga. And there's been some very historic events there in the last 4 weeks. Most people locally know that Clint Halftown has clung to power there despite clear removal by his clanmother and a new unity council where all 3 clans have come together and formed a new government in 2011, and he just refuses to accept that. So on April 28th, the Unity Council and their supporters decided to take possession of the business properties that were being run in both Seneca and Cayuga counties. And immediately, Clint, there's a term we use in legal circles called lawyering up. Never a very positive term. It has kind of a flexible meaning in different situations, but in this situation it means that they're spending tens of thousands of dollars an hour paying lawyers from Washington, D.C. and New York City and big firms here in Syracuse to try to cling to power there. So they ran into both Seneca and Cayuga County Supreme Courts, got immediate temporary restraining orders without our side being able to be heard. Those orders ordered the removal of the traditional people. And when they would not leave, they went back 3 days later. So every morning I would get an email with about an inch of paper attached to it from these super lawyers. And so they got another temporary order that said if you don't leave in such and such a time, you'll be held in contempt. All this time before we've even been able to put 1 page of information in front of the judges. At several points, they kept pushing these judges to issue orders to the sheriffs to forcibly remove people. And we finally got our papers in. We went to Seneca County Court last Friday and argued that the case had to be dismissed for a combination of reasons. Primarily because it's very clearly an internal struggle within the Indian nation over leadership, and that is way beyond the subject matter jurisdiction of the state court. Actually, the county, Seneca County, agreed with us there. And last Monday, we got a decision that dismissed their case. Took the order off the backs of the Cayuga people. The next day, we went to Cayuga County to argue the same situation. And from the bench there, the judge joined with Seneca County and dismissed Halftown's case, taking away all the orders there. Before I walked out of court that same morning, thinking, well, we've done pretty good here, they served me with about that much paper, filing in the appellate court in Rochester, asking for the same temporary orders that they just lost a half an hour before. So yesterday, with the help of some lawyers who are helping us on everything, Alex Page, Curtis Berkey, and Janet Gansworth, a young Tuscarora woman recently admitted who was in my office, we filed this response in Rochester about 4 o'clock yesterday afternoon. So that's why I haven't had as much time to prepare. The good news is that the rules in the appellate court are much more fair, that you can't just run in and get a temporary order without the other side being heard. And so rather than having our friends out there risking arrest and worse, at this point there are no court orders against them. And that's the way things are at Cayuga. They are in charge of and running one of the 2 stores, Lakeside 2 store in Seneca Falls. That income now goes to the Cayuga people rather than Mr. Halftown. They're also in charge of offices there, and begrudgingly there's a standstill agreement where there's an agreement that Mr. Halftown won't send his private security forces in there to try to retake them. So that's just another 6 weeks in Indian country, really. So that's what we're doing here, and it really all keeps coming back to how amazingly off base Indian law is in the United States now. I've spent pretty much the last decade trying to figure out some of the Supreme Court rulings from Sherrill and everything else, and it's very much like Phil said, it all comes back to the doctrine of Christian discovery and the fact that all of our law is based on that. The fact that every piece of land in the United States is stolen Indian land, and the inability of the legal system to come to grips with that fundamental truth. Because until you do, you're going to keep making up rules the way they have been, and indigenous people are going to be denied their rights to their land. And so the movement against the doctrine of discovery is very, very critical, both in the legal work, but in all of the political work that we have to continue. And so most people locally, I'll run over the history of the land rights action very quickly. We filed it in federal court here on March 11th, 2005. Within 3 weeks, the Supreme Court issued the Sherrill decision. And there they said they made up a new defense that hadn't even been argued to them or presented to them by the state and the counties in the city of Sherrill. And they said, essentially, you can't have any remedy for treaty violations because you waited too long. They gussied it up, saying in the name of an equitable theory called latches, it's not fair for you to raise these problems anymore. And we'll come back to that in a minute. Most of you are pretty familiar with Sherrill. That fundamentally changed Indian law, or perhaps put the ribbon on the, well, you couldn't call it a package, but it's just that it really just carries all of the problems that have been brewing for over 200 years and crystallizes them. And perhaps they've done us a favor, because there's no more pretension that there's any justice for indigenous people in our courts. So after Sherrill, in June or July of 2006, the Second Circuit took the Sherrill decision and dismissed the entire Cayuga Nation land claim, which had been pending for about 3 decades, and at that point was really just a monetary judgment of about $250 million. And we're scratching our head trying to figure out these defenses that they're making up as they go along. So eventually, in August of 2010, the Second Circuit dismissed the Oneida land claim after a lot of appellate work back and forth. And then, based on that, the district court dismissed the Onondaga land rights action in September of 2010, without ever really giving us any opportunity to present our case. We had a 1-hour oral argument. That was the day before Columbus Day in 2009. And they said that because the circuit had dismissed Oneida, he had to dismiss Onondaga. We took that to the Second Circuit to appeal that dismissal. I got to argue that case for 10 minutes on Columbus Day, October 12th. I guess that was 2012. Very interesting historic ironies in all of this. So then we petitioned to the Supreme Court, knowing that they would deny certiorari, that's the term for whether or not they would review it. And they issued that decision the day after Columbus Day last year, 2013, October 15th. That created the 6-month window. So that's a short rendition of the federal court history. And we have known, I think, since about a week after Sherrill that we were not going to get justice. And so we've always been thinking about and preparing for moving into the international arena. Really, the Onondagas began that in 1977 when they began to go to the UN. And all of the work that they've done in the UN since then, particularly within the Permanent Forum on Indigenous Issues, which just completed, and Betty will bring us up to date on. And particularly culminating, as we know, in 2007, September 13th, when the General Assembly adopted the Declaration on the Rights of Indigenous People. So we worked for the last 6 months, between October and April, to put together a petition to take the United States to the Organization of American States Inter-American Commission on Human Rights. It's one of 3 possible international fora where we could bring the United States to try to hold them accountable. It has actually the best case law. It has dealt with many, many more indigenous nations' human rights violations petition than any other of the 2 available UN agencies that could hear this. And it also has a 6-month time frame which had to be met, so that if we didn't meet that, we would have not been able to exercise our rights in that body. The first decision that the Inter-American Commission handed down, the most significant one, is in 2002. They awarded the Dan sisters and the Haudenosaunee a decision against the United States. And there have been a series of other decisions for other indigenous nations throughout Central and South America in the meantime, and there's a very strong jurisprudence or set of decisions that says that when you take original lands from indigenous people illegally, that's a human rights violation. Pretty fundamental, but certainly different than the last court that we were just in. It also says that when you take land from indigenous people and then wreck it environmentally, that the environmental damage that happens to the people and the land is also a human rights violation. And finally, there's a principle particularly built into the United Nations Declaration on the Rights of Indigenous People that says that a country, they're called states in international law, that a state must have a legal system that provides remedies for treaty violations. And we clearly don't have that in the United States now. So those are the 3 basic human rights violations that we have filed against the United States. It's a very deliberative process. I think since we filed, they've managed to put a case number on it. And there will be months before much of any activity goes on there. It's not really a court, but it will be a very, I think, significant accomplishment in the long run of regaining the recognition of the rights of the Onondaga and other Haudenosaunee people to their land, because it can, and we hope certainly will, issue a ruling that the United States has committed human rights violations, and that based on that we can move forward to perhaps finding some real justice here. It does not have enforcement powers against the United States because they will not agree to the jurisdiction. There is an Inter-American Court on human rights violations. The United States won't agree to its jurisdiction. So that's a quick overview of that we have filed with. There are copies of it available on the Onondaga Nation website, and we can come back to that later if we have time for questions. This is a copy of the petition, and it has a lot of exhibits, historical exhibits again, and the petition itself is about 50 pages of single space. So, I'm excited that we were able to file that for the Onondaga people. I think it's very historic, and we need to, as I've said several times, as this land rights has taken its torturous path through U.S. courts, we all know that the solution to these historic problems is political. The chance of getting any real remedy out of U.S. courts, I think we've pretty well exhausted. And so we need everybody's support to continue to join the Onondagas, because we know that when they filed this action, they called for a healing of that lake and all the rest of the destruction, and a healing of the relationships among those of us who are settlers and living on the unadopted land, so that we can all work together to protect the natural world. And we just need you to continue to do that, because the support that the Onondaga Nation has been very, very important to them, to our office, and it's how we're ever going to find justice down the road here.
So let me move now to the doctrine of discovery. And this paper that I have in my hand, we did not make copies of, because Phil correctly said we should limit the amount of paper that we're doing.
It's online.
I think it is available online, and Phil can explain that. So that's the title of this paper. It's about 30 pages, sorry. And what I tried to do with it was to explain the importance of the doctrine of discovery in Indian law. And it comes out of work that we did in 2009 and 2010, when there was an important debate going on nationally among some Indian scholars and practitioners, some of whom were saying, well, the doctrine of discovery really isn't a problem. One draft of a paper that we saw said it's really good for Indian nations. When we saw that, I was asked to begin to prepare a rebuttal to that. And we did that. We went to a conference on that draft. It improved slightly, and then we could see that it wasn't going in the right direction, and I was asked to write, to look back at all of the Supreme Court law and just have a record here of how bad the law was. So we did that. We sent that off to the author of that study. Just like the federal government, it was ignored. And there's now a book out that you can buy for about $600 that has this theory that the courts have never used the doctrine of discovery against Indian nations. So we have tried to push back against that clearly erroneous position, and this paper is a result of that. And Phil was kind enough to prepare this PowerPoint because he knew, because I said I don't have time to think, I'm typing to keep the community situation. So some of it is repetitive, and I'll try to get through it without too much wasted time. So the first thing that we need to do is set a very basic reality, which is that sovereignty is the basis of Haudenosaunee's views towards their land. And any discussion of land rights needs to begin with sovereignty. And actually we raised a criticism of the paper that I spoke about, saying it never mentioned sovereignty, and they said, oh, well, we'll get to that in another paper. And yet it purported to be the definitive new text on Indian law and in land law. So we always have to begin with sovereignty, and to say that there's nothing acceptable about the doctrine of discovery. And then we need to go back and think about what Vine Deloya wrote in quite a while ago, I think in the 70s. And he wrote that the questions of theological nature arose. Who were these newly discovered people? What rights did they possess? How were they to be treated? And he went on to point out that Christian monarchs created a system that whoever discovered lands inhabited by non-Christian people would have the exclusive rights to extinguish such Indian title against other Indian nations, against other European nations. Sorry. And the present position of the United States is that it holds our lands and community, this is Vine continuing, as its wards. When this current doctrine is traced back to its original, it lands comfortably within the doctrine of discovery. The United States claims its rights over us not by right of conquest, but by having succeeded to the rights of Great Britain to extinguish our titles to our land. And he wrote that we will continue to have difficulties maintaining our lands, our communities, and cultures so long as the major reason that they are protected is to enable the United States to one day distinguish them as its legal right against other Christian nations. So this is 40 years ago, Klein wrote this. And he also, of course, we know this, that it all goes back to the papal bulls and to Cabot's, John Cabot. Actually, that's not his name. He has a very long Italian name. He's not English at all. Was not English. And we'll come back to this when we get to Johnson versus McIntosh. So, but it's important to look at the Cabot Charter because what happened in Johnson versus McIntosh, we'll have a quote soon from a good friend of ours, Lindsay Robertson, who's a professor and historian that explains the historical context in a book that he wrote called, the title escapes me, but it's important to understand that in Johnson versus McIntosh, Chief Judge Marshall spent pages writing about the Cabot Charter and all of the rights that came to the dominant colonial powers that then transferred to the United States. And it goes back to the papal bulls again. Most of you are probably better versed in them than I, but we know that it goes back to the papal bulls from the 1450s originally, when the colonialism began so heavily in Africa, and then shortly the year after Columbus discovered the Western Hemisphere, a new papal bull followed within 3 years by the King of England, because the churches were fighting, doing exactly the same thing in a charter to Cabot. And we also know that there's been a strong movement against the doctrine of discovery, and we wanted to make certain that when we argue against the bulls, that the nation agrees with the Declaration of Vision that's drafted by the indigenous delegates to the Parliament on World Religions in 1992. And again, I won't belabor reading this, but it's the it concludes with the U.S. Supreme Court and Johnson versus McIntosh adopted the same principles of subjugation expressed in the Inter Caetera Bull. And so there was a call for the Vatican to clearly and specifically denounce and revoke the bulls. That movement continues today, and perhaps with this new pope we might get there. And so this is a statement that the nation made back then, that in the law paper that I talked about before. But interestingly enough, we always hear as a starting point Johnson versus McIntosh. I just want to point out that as early as 1810, and if you think about that period historically, it's just before the War of 1812, and what's going on at that period of time, we know, is that every founding father is a land speculator. Washington, Jefferson, Marshall. That's how wealth was made. It was either made by stealing Indian land and then flipping it, selling it for much more, or from slavery. And so New York, after it stole the land from the Onondagas, sold it for 5 times as much, almost immediately. That's how wealth was made back then. Washington is quoted at one point of looking over Oneida Lake at the vast empire in front of him. And so that's the struggle going on at the time. And the courts are very new. And in 1810, in Fletcher versus Pitt, this was written. I think it's important just to understand that this is really the beginning of invoking the doctrine. Marshall just glorifies it much more 13 years later. So the court writes, what is Indian title? It is mere occupancy for the purpose of hunting. It is not like our tenures. They have no idea of a title to the soil itself. It is overrun by them rather than inhabited. It is not a true and legal possession. It is not a right to be transferred but extinguished. So here we have you see the basis of this concept of terra nullius, that, there's not really people living on the land, they're really the same as the animals that run across the land, and they have no more rights. That's a fundamental principle of the doctrine, as we all know. And it went on to say, the Europeans found the territory in possession of a rude and uncivilized people, consisting of separate and independent nations. I wonder what happened to that concept. They had no idea of property in soil, but a right of occupation, a right not individual, but national. This is the right gained by conquest, and the Europeans have always claimed and exercised the right of conquest over the soil. So here we see the racist ideas of uncivilized people, because you don't know enough to carve up the land and individually hold it and ruin it, but that you would have the nerve to own it collectively for the better good and for the good of future generations. The arrogance of that kind of capitalist theory of land ownership is profound, and it leads to making a sacred lake the most polluted lake in the country, and then calling that development when you justify continuing to hold the land against the people that have the original right. So that starts in 1810, not 1823. Then in 1823 we have Johnson versus McIntosh. You can read the paper, and then after that, if you send me an email, I'll send you the quiz to follow up on the paper. This is the seminal case that we all go back to, and that's cited again and again. And as Phil pointed out, in Sherrill, as they're making up this new defense to deny justice, the first footnote goes back to Johnson versus McIntosh, and specifically cites the doctrine of discovery. Now, there's some Indian lawyers that say, oh, but that's not really the basis of the ruling. It is, because it's all founded on this bad foundation. So let me try to keep things moving here. So Lindsay Robertson wrote the book Conquest by Law, and I just want to read this because it's really important what he discovered. And it turns out that Lindsay, as a historian, he's also a law professor at the University of Oklahoma, was digging into some of the family papers that led to the case, and discovered some of the original papers in an attic in Pennsylvania about 15 years ago. And from that, he writes this introduction. In 1823, Chief Justice John Marshall, a Revolutionary War hero, former Virginia legislator, and well-known land speculator, handed down the case of Johnson versus McIntosh. And from the beginning, it was all about land. About 43,000 square miles of lush, rolling farmland in Indiana and Illinois where the rivers convene. At the heart of the decision was a discovery doctrine that gave rights of ownership to European sovereigns who discovered the lands and converted the indigenous owners into tenants. Though its meanings and intentions have been fiercely disputed for over 175 years, the doctrine remains the law of the land, and indigenous people all over the world have been dispossessed by it. But what he exposes then is that the case was just set up, made up, concocted in order to get to the Supreme Court, to get this ruling, to justify further land grabbing and taking from indigenous people so that they could flip it and speculate on it and make profit. And so he says that it's a collusion case, an attempt to buy off many of the leading figures of the early republic, including the lawyer for one of the parties, and to take advantage of loopholes in the early federal judicial system in order to win a favorable decision. So, and he goes on to explain all of that. It's a great book. If you haven't read it, I think it's very well worth the time. Lindsay, by the way, was one of the historians that wrote a major report in support of our land rights action back in 2008 or 2009 when we submitted 1,000 pages. So we all know it starts in Johnson versus McIntosh. And we will just skip over most of that because what I really want to show and again, we have, and what what Lindsay says in his introduction is the case could have been decided in about a paragraph if it had been limited to the simple legal principles involved. Instead, Marshall wrote a 33-page opinion that goes on for pages and pages about the history of the doctrine of discovery. He mentions the papal bulls. He mentions Cabot's charter, because it's England that took most of the land north of Florida. And so that charter becomes the excuse for the United States to bring the doctrine into U.S. law. And it's the same fierce savages, unknown Christian people, natives who were heathens, heathen in barbarous lands. This is our Supreme Court that writes so freely about equity. And he concludes with the absolute ultimate tile has been considered to be acquired by discovery, subject only to the right of occupancy, which can be extinguished at will. So that's where it began, and then it only got worse. So here are a couple more of the bad decisions along the way, but the real crowning low point is the Teton case, 1955. And there, this was a case involving indigenous people in Alaska. And there, the ruling was essentially that the government can take indigenous lands at will and doesn't even have to pay for it. Which is in clear violation of constitutional principles. And it concludes with the line of cases adjudicating Indian rights on American soil leads to the conclusion that Indian occupancy, easy for me to say, not specifically recognized as ownership by action authorized by Congress, may be extinguished by the government without compensation. And here's the line that really is, you should take home with it. Every American schoolboy, and I suppose schoolgirl, knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of land by treaty in return for blankets, food, and trinkets, it was not a sale, but the conqueror's will that deprived them of their land. 1955. So, the other problem that we have in addition to the doctrine of discovery is what's called plenary power, which essentially is a concocted theory that Congress can end any Indian title or right merely by a stroke of the pen, and that this power is unchecked. And so if a treaty has a provision that's problematic to the dominant culture, the dominant government now, Congress will just say that that part of the treaty's gone. And this concept of plenary power continues in U.S. law today. These are the kinds of principles that we're trying to get, that we now have in front of the Inter-American Commission. Because when you try to talk about this stuff in U.S. courts, they tell you it's not fair to talk about it anymore. So, plenary power is essentially made up. It's a very, if you really want to read an opinion that's scary, and there's some quotes in the paper, read the Kagama case of 1886, which is often still quoted today. These are historic periods where there was no attempt to be politically correct, and where the thirst for Indian land was unchecked, and the constant stealing of Indian land was just going on like the railroads. And this is the same period of time that it was ruled that there would be no more treaties. And so this case talks about Indians being wards of the nation, pupils, dependent nations, always needing the protection of the more civilized dominant culture. Then we have Oliphant, which is a pretty important case from 1978. So there's a whole series of these cases that are quoted from pretty extensively in the paper. But here's one, the Mayfield case. The court noted that the policy of Congress has been to allow the inhabitants of Indian country such power of self-government as was thought to be consistent with the safety of the white population, which may have to come in contact, and to encourage them as much as possible in raising themselves to our standards of civilization. You couldn't make this stuff up. And it goes on. Around the time that we were engaged in that debate that I talked about the paper that's now the book, here's a decision from the Sixth Circuit. I think most of us know that we have district courts at the lowest level of federal court, circuit courts of appeal, and then the Supremes. So here's the Sixth Circuit ruling in August of 5 years ago. This is a fishing rights case. And clearly I think it's the Ottawa Nation, yes, was trying to reassert fishing rights that were clearly established for them in a treaty, I forget the year, pretty early treaty since it's Ohio. And that was just flatly rejected using the Latches defense that but actually not mentioning Cheryl, which is really scary. We hold that because the tribe, under these treaties, retained at most a right of occupancy to the land in Ohio, and that this right was extinguished upon abandonment. So you remove the people from the land and call it abandonment and say you lost all your rights because you took off. Any related fishing rights it may have reserved were similarly extinguished when the tribe removed west of the Mississippi. This is the kind of stuff written 5 years ago. And it goes back to an older case. So these new cases still keep citing cases that are 80, 100, almost 200 years ago. And the result is that there's no justice left for Indian nations. So our conclusion in the paper was that the U.S. courts have consistently used the doctrine of discovery to deny land rights. The fact that somebody would write that the doctrine is somehow, we shouldn't worry about it. That's the theory that we have to argue against. Clearly, we all know better than that. And in order to continue our work to eliminate the doctrine of Christian discovery, we know that it's going to take years to correct some of the court cases that we've seen. And it's only going to come about in the same way that the change from Plessy versus Ferguson to Brown versus Board of Education took place. And that's a strong political movement in support of this very necessary need to correct this historic inequity. And so we just have to, as so many people have done for so long, maintain the long vision, thinking of the rights yet to come. And we need to push the United States to actually implement the Declaration on the Rights of Indigenous People rather than sort of recognize it and say, oh, well, we'll do that as long as it doesn't conflict with our domestic law. We need to keep participating in international movement and the meetings at the UN and other international bodies. We need to be in international bodies, and we need to advocate there. And just what the Haudenosaunee are doing, being sovereign. So that's a quick overview of how this law continues to this day. Starts in 1810, gets crystallized in 1823. Actually, Marshall tried to back off a little bit from what he had written in 1823 in some of the cases like Worcester versus Georgia that took place in the early 1830s. But
time and again, when push comes to shove and Indian nations are really looking for justice and they get to the Supreme Court, it keeps coming back and it keeps getting even worse and worse and worse. And so right now we have the situation where when the Second Circuit dismissed the Oneida land claim in August of 2010, they said, well, we've used the term latches as a convenient shorthand, admitting that they've just made up a new equitable defense. So in the name of equity, which we all know is fairness, they have said that there's only two elements that the state has to prove if an Indian nation raises old rights. One, that there's a long passage of time. Well, clearly the Haudenosaunee treaties are a long time ago. Still valid, still should be honored under international law. And two, if the issues you raise might disturb the people, the settlers that are on your land, then it's not fair for you to raise these objections anymore at all. And we're going to dismiss your case in the name of fairness. That's the current explanation by the Second Circuit. It clears up a lot of things. We were trying to see how this fit into any pre-existing theory of law and equity, which it doesn't. And then they went on to say, and this defense only applies to Indian land rights at cases. Separately. So, you see how fundamental this racist concept is to our law. And so the work that you're doing here and in the committee and that you carry on within your churches is very, very critical to the healing that's necessary in this country. And so we really appreciate you being here and listening to me today. Thank you.